So again, good afternoon to everyone. This is the topic for today's webinar, Local Governments in Action, Their Powers and Limits. We will cover their powers and limits not only during extraordinary times like today, but also their powers and limits during ordinary times. So I will make a comparison of ordinary and extraordinary times. So good afternoon to my fellow public servants, classmates, schoolmates, students, former students, and to my friends at the DILG and to the leagues of local governments, League of Provinces, Cities, Municipalities. Magandang hapon sa ating lahat. By the way, let me extend my appreciation to those who sent in their questions prior to this webinar. I will attempt to answer all your questions and integrate my answers as part of the lecture proper. So today we will cover some sensitive areas of governance. What are the do's and don'ts of local governance today? What is the extent of local autonomy today? Is there a change in local autonomy under extraordinary times? We will answer those questions. For those of you who attended the first webinar, I mentioned there the term enhanced supervision. And so far as local governments are concerned, I have a number of slides on this issue, so we will go through that somewhere towards the middle of our seminar. By the way, I will also, as part of this webinar, discussing some of what I feel are the proposed amendments to the 1991 Local Government Code, although temporarily, because these amendments were brought about by the Bayanihan Act, which will end in June. But if you read in the newspapers recently, there's a proposal to extend the effectivity of the emergency powers of the President anywhere from 3 months to 6 months. So hintayin po natin kung gaano katagal ang magiging extension of the emergency powers of the President. So let me begin. Local governments, whether in ordinary or extraordinary times, are in the middle. Some people say that they're caught between a rock and a hard place. They're caught because they have dual loyalties. They have dual capacities, both in their governmental and private capacities, and therefore they serve two masters or two bosses. They serve the state in the exercise of their governmental functions, and they also serve the people in the promotion of their general welfare and in the exercise of the local government's proprietary functions. Local governments are partners in development. There can be no true national development without the development of local governments. That's essential under our current system. And if you look at the fourth bullet, local governments must respond to the needs of the people, and at the same time, they are accountable to the state and accountable to the people. So local governments being in the forefront, being in the middle, they are what I call institutional frontliners. This is a slew of screenshots from the DILG website from the time of the lockdown. The DILG has issued a lot of circulars. I was able to go over 66 memorandum circulars, and every so often DILG comes out in the news. So here it's a combination of directives from the DILG, and at the same time we see the consequences of not following the directives of the DILG. So let me just highlight a few of these news items. The DILG said to the public, breaking quarantine directives is a violation of the law. Show cause orders have been issued to some local government officials. There's no mandatory COVID testing for returning workers. So these are the directives from the DILG. Some of you might be asking, are these directives valid? So we will be discussing this particular issue as we go through this webinar. On the part of local governments, we've seen in the newspapers and in the news, a lot of our local governments have issued executive orders and they have enacted ordinances on the following topics. Lifting of the liquor ban or imposing of the liquor ban, imposing a curfew, closure of malls, anti-discrimination ordinances, regulation of tricycles, extension of the payment for local government taxes. So we have this, a lot of these ordinances enacted by local governments. Some of the questions that were forwarded to me is, are local governments, are local chief executives empowered to issue executive orders even without an ordinance? I will give my opinion on that particular issue shortly. So again, the earlier slide tells us what DILG has done. And on the other hand, what local governments have done during this pandemic. I have 9 topics for today's discussion. Nature of local governments, local autonomy, what is supervision, what is control, how do we resolve conflicts. The more interesting topics will be about the Bayanihan Act and what I call the enhanced supervision, what would be the menu of powers of local governments, powers of our sanggunian, powers of our mayors, governors, and punong barangays. And lastly, we will end our webinar with the discussion of the accountabilities and liabilities of local government units. So let's now proceed with topic number 1. How do we describe local governments? If you recall our discussion last time on the administrative law, we need to know the admin agencies. And one way of knowing these admin agencies will be to examine their. So here, there are 12 features of local governments. Number 1, they are administrative agencies. Compared to national government, local governments are local. Their coverage would be, their geographical scope would be local. Local governments, since they perform aspects broadly, that is of the sovereign functions of government, they are considered as public offices. They are also considered municipal corporation proper because of their territorial jurisdiction. In the 1987 Philippine Constitution, they are referred to as political because they perform obviously political functions. Territorial because their jurisdiction is defined by metes and bounds in their charter. And a very important term would be the term subdivision. Local governments form part of one unit, and that we call the state. Currently, we are not under a federal form of government. There are attempts to shift to such a system wherein the states would have a claim against the federal government, but not at this point. At this point, under our constitution, we're under a unitary setup, meaning there's only one unit, and local governments are referred to as subdivisions or subunits of that unit. Right now, under our current constitution, there are 5 levels or 5 types of local governments, the biggest of which would be autonomous regions, although 2 have been identified in our constitution, only 1 has been incorporated in the autonomous region. We have provinces, we have cities, we have municipalities, and we have barangays. In my earlier slide, I referred to local governments as double agents. Why? Because they are not the principals. They serve the interests of their 2 bosses, namely the state, in the performance of their governmental functions, and the people in addressing their special needs. Local governments are frontliners. The rule is in addressing local concerns, assuming there is no law which says otherwise, in addressing local concerns, local governments must prevail over national government and government corporations. Because we have seen a lot of Supreme Court cases which have said that local governments have superior competence in terms of addressing their own concerns. But there are exceptions to this rule. Again, earlier I mentioned if the law says otherwise, then we must follow the law. I have a slide in terms of how to resolve conflicts between and amongst local governments and the national government. Currently, we have a system of separation of powers wherein executive power is given to the local chief executive, while legislative power is given to sanggunian. Again, it is up to Congress in the exercise of their their control over local governments under Section 3, Article 10 of the Constitution. It is up to the Congress to determine and to delineate the functions within amongst the branches of local governments. Congress can create local governments for barangays. Other than Congress, the province can likewise, and cities can create barangays. Local governments are delegates. They cannot disobey the law. They cannot disobey the Constitution. And we must also distinguish between the officers and the local government units themselves. Local governments are juridical persons, and we must distinguish the personality of these local governments from the personality of the local officials. And lastly, the last feature is despite changes in the administration, kung nagbago na ang mayor or ang governor o ang punong barangay, contracts, ordinances enacted by the previous must be respected by the incumbent. Unless, of course, the other party would agree to any change in the contract. Because as we all know, the real party to a contract is not the local chief executive, but the local government unit itself. Proceeding now to our second topic will be a discussion about local autonomy. Again, is it different now because of the Bayanihan Act? We will discuss that shortly. But first, let me give you a definition of what local autonomy is. And where can we find this definition? We find this definition in Section 3, Article 10 of the Constitution, which says, and this was affirmed by the Supreme Court, by saying that local autonomy means, and this is a very important word, the qualifier word, more, it means a more responsive and a more accountable local government structure. Earlier, I mentioned the term responsible and responsible, instituted through a system of decentralization. So that is the meaning of local autonomy. Despite local autonomy, despite giving more to local governments, their powers are not absolute. Their powers are not limitless. While their powers are broad, they are not without limits. Local autonomy does not make local governments or does not convert them into states. We have two levels of decentralization, which I will discuss shortly. We will also define what devolution and deconcentration, what these terms are. Local autonomy is not a license for local governments to violate the law. Under the definition of local autonomy, only Congress can impose limitations on the powers of local government units. Absent a law, national governments cannot limit or restrict the discretionary powers of local government units. But the question now is this rule applicable today in the Bayanihan Act? And I will respond to that shortly. Local autonomy gives local governments discretionary powers and allows for diversity. However, under the Bayanihan Act, there's a requirement for uniformity. It also acknowledges the superior competence of local government units, but things may be different today under extraordinary times. And lastly, local autonomy necessarily includes fiscal autonomy. When we talk about fiscal autonomy, local governments have the freedom, although this is not absolute in terms of where to use their funds and how to source their funds. Local autonomy has 6 Ds. Decentralization, powers given to local governments. Delegation, which are state powers given to local governments, like the power to tax. Discretionary powers, although today these powers have been constricted. Devolution, or those powers coming from national government agencies. Deconcentration, which are powers from national government agencies transferred to field offices of these national government agencies. And lastly, one of the hallmarks of the 1991 Local Government Code is giving ordinary citizens, people's organizations, non-governmental organizations, the right and opportunity to participate in local governance. Just a few terms. There are 2 types of decentralization. One, which talks about administration, and the other one, which talks about power. Right now, there's only one entity. There's only one local government unit which enjoys a higher degree of decentralization, and that would be the Bangsamoro Autonomous Region in Muslim Mindanao. They enjoy a higher degree of autonomy, and that is what we call decentralization of power. For provinces, cities, municipalities, and barangays, they only enjoy a lower degree of decentralization, and that is what we call decentralization of administration, basically pertaining to regulatory, administrative powers, and the responsibility to deliver basic services. Another set of terms which you need to be familiar with would be the terms deconcentration. This is a transfer of powers from a central national government office, let's say the Department of Public Works and Highways, to their field offices. As distinguished from the term devolution, these are powers from national government agencies or government-owned and controlled corporations or government instrumentalities, and the recipient of these powers are local government units. There are 4 items which are devolved. These are the powers to regulate, the responsibility to deliver basic services, assets, and personnel. Before I go to the next slide, let me underscore the phrase power specific when we talk about devolved powers. And what do I mean by power specific? This is a list. This is a list of powers which are once upon a time exercised by national government agencies, but because of devolution under the 1991 Local Government Code and other relevant statutes, these powers are now devolved or transferred to local government units. Once upon a time, let's say for cockfighting, we had the Philippine Game Fowl Commission. Now, this power is now with local government units. Let me underscore the one regarding driver's licenses. Can a local government unit, through an ordinance, issue driver's licenses? The answer is no, because this power remains with the Land Transportation Office. This power has not been devolved to local government units. So this is precisely what I mean by the term power specific. In one case, one province issued a cable TV operation franchise. The Supreme Court said that this power remains with the National Telecommunications Commission and cannot be devolved to local governments because it is not one of those powers listed as a devolved power. So again, the rule is, if it's devolved, it is now local government. If it is not devolved, it remains with the national government. So decentralization means that not all powers of government have been devolved or have been transferred. There are centralized powers and there are decentralized powers. A question to all of you. And again, are you a rightist or are you a leftist? What do I mean by subscribing to the right view. Right view means that a local government can only exercise those powers given to them. LGU actions must be consistent with law. It's like a cut and paste approach. That is the right view. What is the left view? The left view talks about powers given to them and those powers which are not otherwise inconsistent or prohibited by law. In short, let me phrase it in Tagalog, pag right view, kailangan ibigay. Left view, basta hindi bawal, pwede. If there's no prohibition, then it is allowed. So the left view would subscribe to a more innovative approach towards local governance, although there is some risk because there is no law which defines that power. There's no prohibition, yet under the leftist view, if I may call it that way, then local governments can take action. So again, no need to give me your answers, or if you want, in the Q&A portion, let me know whether you subscribe to the right or the left view. If you look at this slide, basically the right view is the centrist view. The left view is the liberal view. Under the liberal view, for as long as there's no prohibition, for as long as it will serve the general welfare, even if it was not given expressly to the local government units, then under the liberal left view, local governments can exercise these powers. Under the centrist view, there must be an express delegation. Otherwise, local governments cannot perform these powers. Personally, I subscribe to the liberal view, but that's in class, I give these two views. And again, it's up to everyone because our Supreme Court in several cases have adhered to the liberal view and in certain cases have adhered to the centrist view. Proceeding now to the next topic, what is supervision and what is control? Here, I've attempted to draw, if you may, an organizational hierarchy showing our number one supervisor, our top supervisor, which is the president, all the way down to the barangays. If you look at the lines, if the unbroken line talks about the president's direct supervision over the local government or the higher supervising LGU over the lower supervised unit. If you look at the broken line, it talks about indirect supervision. So for example, the president exercises direct supervision over the province of Bataan, but it only exercises indirect supervision over the component municipalities, even the barangays of Bataan. Who would exercise direct supervision over the barangays? It would be the cities and the municipalities. Okay, so again, this is a graphical illustration of the hierarchy. So effectively, the president, under ordinary times, cannot suspend a punong barangay. The punong barangay can only be suspended by the one who exercises direct supervision over it, namely the municipalities and the cities. Here's a slide which tells us, compares and contrasts what supervision is and what control is. Supervision is the power to oversee, to check if the supervised unit or officer is following the law. Under a supervision relationship, the supervisor cannot change the decision of the supervised, which is different from control. Under control, whether the supervised, the one controlled, does a thing which is right or wrong, the one who has control can change the decision of the one being controlled. Under the system of control, discretionary acts can be altered by the one who has control. If a relationship is one of control, the one who has control can prescribe the manner by which an act is done, which is not the case for supervision. In the case of supervision, a supervisor cannot prescribe the manner by which an act is to be done. But if I may say, this is different now under extraordinary times. And I will explain that later. Now, national government can prescribe the manner by which an act is done. And for those who will disobey the prescriptions of the national government, they can be penalized. And I will explain this shortly. So now there are certain aspects of control which we find present today. But let me clarify that under the 1987 Constitution, there's only a system of supervision between the higher local government and the lower, and between the president and local government units. But again, let me qualify that there is some change under the current setup, and I will explain that shortly. I will not go through this slide in detail. This particular slide just illustrates what control means, what a supervisor can do. And if you recall, for those who attended our webinar last May 11, we talked about the rule on attachments. Here's an illustration under ordinary times of what supervision and control is. Let me give an example of supervision. The power to declare an executive order or an ordinance illegal through review. Right now, there are two agencies of the national government which has this power. The Department of Justice can declare illegal a tax ordinance. The Department of Budget and Management has the power to declare an appropriations ordinance illegal. There's no other. But again, the province also can declare illegal an ordinance enacted by a component city or municipality, and a municipality and a city can declare illegal an ordinance of the barangay. But going to the national government, right now there are only two national government agencies which have the power to declare actions illegal. But the power to declare illegal does not mean or cannot amount to changing the decisions of the supervised unit or changing the choices made by the supervised unit. In terms of control, right now this is exercised by Congress. Congress was the one who defined the structure. Congress was the one who determined that a mayor shall be an elective official. Right now, under our statutes, it enumerates the qualifications and disqualifications of local officials. Right now, we have, once upon a time, it was the Internal Revenue Allotment, but under a recent Supreme Court case, this has now been denominated as the National Tax Allotment, because the Supreme Court said that for the past so many years, local governments have been deprived of their share from other taxes other than those and revenues collected other than by the BIR. But however, despite the fact that under our Constitution, the President only exercises supervision over local governments, there are two provisions in the 1991 local government which talks about control. The power of control by the Department of Health during epidemics, and the power given to the DNR in terms of the implementation of community-based forestry projects. Let me just connect the provision in the 1991 Local Government Code giving control to the DOH to RA 11332, which is a relevant law at the moment regarding notifiable diseases. It gives the DOH the power to declare an epidemic, whether it's national or international. If the epidemic will cause or will threaten the national security, then the President has that authority. And for local outbreaks, the local governments can declare a territorial disease outbreak. Going to conflict resolution. How do we resolve conflicts between national on one hand and local government units on the other? But before I give you the rule on how to resolve conflicts, this slide is a summary of around 50 Supreme Court cases. On one hand, local government units won. Let me give an example. The DOJ cannot declare a tax ordinance as excessive because that is not a question of law. MMDA cannot direct subdivisions to open their gates for private users because only local governments have police power and the power to legislate. On the other hand, there are certain cases to your right wherein the national government became victorious over local governments. Like local governments cannot ban lotto outlets within their jurisdiction. Local governments cannot issue franchises for cable TV operation. Going back to lotto outlets, while local governments cannot ban the operation or establishment of lotto outlets within their jurisdiction, under a devolved power, which is the power to implement and enforce the National Building Code, they can impose stricter requirements in the National Building Code over lotto outlets. So what is the rule in conflict resolution? If you look at the box to your lower left, the rule is follow the law. Whether it's a national concern, whether it's a concern which crosses boundaries of local governments, then follow the law. Assuming there is no specific provision of law which tells us who wins, whether it is national or local, then we have these two rules. What I call the national dimension rule. The conflict is resolved in favor of national because it involves integration. It's a concern affecting local government, more than one local government. The charter of these local governments have not been repealed or amended. On the other hand, we respect local governments in addressing their local concerns. We call it the principle of subsidiarity because they have the superior competence. They know best. Let me give an example. The photo bomber case in Manila, wherein the Supreme Court said no law was violated. And in the promotion of the general welfare, the Supreme Court respected the exercise of the wisdom of the city government of Manila. But again, the rule is follow the law. When there's no clear provision of law, then we either subscribe to the national dimension rule or the municipal dimension rule. However, as I will explain later, because of the national pandemic, now national government, when there's a conflict, and I will explain this later, when there's a conflict between the Bayanihan Act and other statutes, the national government will prevail. But again, I'll get back to that shortly. Now the Bayanihan Act. We're going now to a discussion of the more exciting topics, the Bayanihan Act and what I call enhanced supervision. The Bayanihan Act enables the president to exercise 2 of the 4 emergency extraordinary powers under the Constitution. Emergency power, if there's a national emergency, as in the COVID-19 pandemic. The power to take over, which is right now in the Bayanihan Act. 2 of the emergency powers are not given under the current Bayanihan Act. The power to operate vital industries or to nationalize current private institutions. Again, these powers are in the Constitution. Right now, the Bayanihan Act is operative. The president, under the faithful execution clause under his oath, must exercise the powers under this law. Right now, this is temporary. The law, the Bayanihan Act, became effective March 27. It will expire 3 months thereafter. Earlier, I mentioned that there's discussion now to extend the Bayanihan Act maybe for 3 months or up to December. So under the Bayanihan Act, necessary powers are given to the president. And we're all too familiar with the reasons of this law because there's a serious threat to our safety, adverse effect on the economy, and to our livelihood. There are 3 important provisions that we must note, again, especially for local governments. Section 4G of the Bayanihan Act, which tells us, which defines the scope of the powers of national government into defined and undefined. I will discuss that shortly. There's a penal clause under the Bayanihan Act for local governments who will disobey national government policies and directives. There's a penalty, there's a fine and or imprisonment. And under Section 7 of the Bayanihan Act, the second sentence, if there's a conflict, then the Bayanihan Act will prevail. Enhanced supervision. If we dissect Section 4G of the Bayanihan Act, there are 2 parts. One, which talks about what has been defined by national government, and number 2, what has not been defined by the national government. If it is defined by the national government, like for example, whether it's MECQ or GCQ, local governments are directed to act within the letter and the spirit of the regulations, and local governments are directed to implement the standards of the quarantine. If it is undefined by the national government, here the Bayanihan Act mentions the phrase, the mandate of local autonomy. However, notwithstanding the exercise or the mandate of local autonomy, if it's undefined, local governments must act within the parameters the national government has set. And number 2, local governments are directed to cooperate. Okay. Going to the bottom portion of this slide, the Bayanihan Act says that all constitutional provisions like the Bill of Rights must be respected. When there is a conflict between the Bayanihan Act on one hand and other laws that like the 1991 Local Government Code on the other hand, the Bayanihan Act will prevail. Local governments must follow not just the Bayanihan Act, but all directives of the national government. Otherwise, they can be penalized. Again, we have read in the newspapers that local governments, some of them have been issued show cause orders. And lastly, let me qualify that the local governance to date is not just about the Bayanihan Act or COVID-19. There are other aspects of local governance. So when we talk about enhanced supervision, we're only talking about the pandemic. But again, largely now, all the concerns are revolved around the pandemic. Who is the national government? When it talks about undefined or defined, basically talks about the president and his alter egos, national government agencies, the interagency task force, and government corporations and government instrumentalities. What is the relationship? Again, earlier I mentioned only Congress exercises control over local governments. Under ordinary times or non-COVID related, there is supervision. But if we talk about extraordinary times, and if it is COVID related, it is Bayanihan Act related, then this is where I where enhanced supervision, and again, this is my term, there is enhanced supervision, meaning during this emergency, this is during the extraordinary times, we are subscribing to the centrist view. We are subscribing to the national dimension rule. There is now a system of uniformity. There are now amendments to the 1991 Local Government Code. And right now, the second branch of the General Welfare Clause, I'll explain this shortly, has been constricted, and the first branch has been enlarged. I will explain this shortly. So there's now wide discretion to national government to define standards. If it's once upon a time undefined, national government can define. National government in defining can now preempt the powers of local governments. Their local governments now have limited discretion because they have to follow national government directives, and if they do not follow, they can be penalized. Executive prescriptions are now allowed. Once under an ordinary system, ordinary times, national government through rules cannot limit or restrict the discretion of local governments. Now, under extraordinary times, discretionary powers can be restricted. And again, lastly, local governments are now liable if they violate the laws and rules. After the Bayanihan Act, after COVID, in October, hopefully, unless of course the Bayanihan Act is extended, we will celebrate the 30th year of the signing of the 1991 Local Government Code. If we recall, former President Cory Aquino signed the 1991 Local Government Code October 10 of that year. Fundamental questions. Can the President or national government change the decisions made by local governments? Can the President or the DILG make different choices on behalf of local governments? My answer is no. They cannot change the decision, but national government can preempt by imposing rules by which local governments must follow. Can national government declare acts illegal other than the DBM or the DOJ? Again, when there's under the Bayanihan Act, national government prevails, local government officials can be penalized, and obviously before local governments can be penalized, there should be a prior declaration that their acts were illegal. Can the President or DILG or national prescribe manner by which local government should act? Again, under the Bayanihan Act, national government in defining certain areas, certain activities have the power to define the standards and quarantine policies. Whether extraordinary or ordinary times, local government officials can be penalized. Now, under the penal clause of the Bayanihan Act, local governments can be penalized for disobeying rules and regulations issued by national government agencies. Here's a slide which I developed just for this webinar. Look at the bottom. So there are times wherein the local government unit acts and enacts. Then two things can happen. National government can agree with what the local government unit did, or national government will disagree and therefore will bar or prohibit that particular act. So if the national government agrees, then the local government will just continue. But if the national government will say that that act cannot be done, then the local government unit should stop. Or if it continues, then it becomes prone to being sued by the national government. So the national government either bars or limits through a circular, through advisories or show cause orders. Even if there's no action on the part of local governments, national government can direct or can preempt through the issuance, again, of circulars and advisories. So in this particular diagram, there's a shift from once upon a time undefined to now or in the future underdefined. So under the Bayanihan Act, local governments can, to my mind, adopt anti-discrimination policies, adopt stimulus program for enterprises, a color coding scheme, impose curfews, issue cease and desist orders for non-observance of the Bayanihan Act and their ordinances. They can still enter into public-private partnerships, let's say, for testing facilities, like what Valenzuela is doing. They can enter into these arrangements or supplemental budgets. What cannot be done, obviously, are those which will violate the standards or policies adopted under the Bayanihan Act or those issued by the national government. So if the prescription is ECQ, then the local government cannot lower the quarantine level. Obviously, the social amelioration program is for the beneficiaries, not for the local government officials. Local governments cannot impose penalties other than those, other than the ceiling imposed by law. Under a recent DILG circular, local governments cannot impose mandatory testing for returning workers, nor can local governments charge fees for passes. Again, these are the don'ts because national government has set the rules regarding these particular matters. Some of you might be interested. I've received some questions. What areas of the local government code have been amended? Again, these are, to my mind, the amendments to the local government code, but these amendments are temporary, only during the time or during the life of the Bayanihan Act. So there are certain restrictions pertaining to the powers of local government to impose curfews, coding for transport. Are tricycles allowed? Because under the local government code, cities and municipalities have been given, because of devolution, the power to give franchises to tricycles. Cockfighting has been banned by the LG. On the other hand, to your right would be some of the budgetary aspects that have been amended. The annual investment program can now be enacted after the release of funds because the rule is prior to the release. There are now relaxed procurement regulations because of COVID. Local governments are now directed by the DILG to postpone the collection of taxes and fees. COVID-related expenditures are now allowed under the 20% development fund. Powers of local governments. We have here, I enumerated 9 of the powers of local governments: police power, eminent domain, and I will discuss these powers, highlight some of these powers. Let's talk about one important power, and that is what we call police power. Police power, in order to be valid, there are 2 requirements. The reason for the exercise of the police power, because when local governments exercise this power, rights are curtailed. Freedoms are curtailed legally. And another important requirement would be how this power is exercised. The Supreme Court has held that both must be present: valid reason and legal means. Here, the Section 16 of the 1991 Local Government Code talks about what we call the first branch, which is the general legislative branch. Talks about the laws enumerate what local governments can do. There's a list. We call that the general legislative. It is what I call a cut and paste. The second branch of the General Welfare Clause talks about principles, talks about guidelines. It gives local governments the latitude to determine what are the particular acts. We call this branch the police power proper. For as long as that particular activity will promote health and safety, peace and order, etc., local governments have the freedom. However, if you recall under my earlier slide, under these extraordinary times, the first branch has been enlarged because of the defined areas, and the second branch has been constricted because once upon a time, discretionary powers are now defined, and therefore their powers are now limited by the rules and regulations adopted to address the declared national policy of the current pandemic. So now, under extraordinary times, first branch became bigger, and the second branch became narrower. As we all know, the difference between police power and eminent domain. Eminent domain, a local government expropriates property, meaning private property now becomes public property for a public purpose. And in this particular case, local government must pay just compensation because someone else will benefit from that taking. Unlike for police power, no one benefits. For example, foot and mouth disease of poultry, no one benefits from the killing of all the pigs, and therefore no compensation is required. Here are just some examples of what can or cannot be done. Local governments now can impose curfew. However, constitutional rights of the minors must be respected. A local government cannot close all the beer houses along a particular street, unless, of course, it's through an eminent domain. However, a local government can close one particular establishment, let's say, for violating the conditions of the business permit. Can local governments impose stricter requirements than those in the National Building Code? The answer is yes, not because of devolution, but because of police power. Local governments obviously cannot prohibit rallies because rallies is the exercise of the freedom of speech of our citizens. Talk about funds of local governments. We have the constitutional sources of funds of local governments, and we have those sources under statutes. Money, of course, is very important insofar as local autonomy is concerned, because this talks about fiscal autonomy. On the right would be the corporate powers of local governments. They can sue and they can be sued. They can enter into contracts, provided there is a prior authorization or ratification on the part of the Sanggunian. Local legislation and executive power. Here, I believe that mayors, punong barangays, and governors can issue executive orders. And of course, our Sanggunians can enact ordinances. Just going to the next slide, I've been asked whether a mayor or a governor can issue executive orders even without an ordinance. My answer is a qualified yes, for as long as no law is violated, for as long as no ordinance is violated, for as long as the Sanggunian does not countermand what the mayor or governor has issued, for as long as the executive order talks about stopgap or emergency measures, and there's this one circular which gives authority to the mayors to even issue executive orders, then my answer is a qualified yes. Mayors and governors can issue executive orders even if there is no ordinance, enabling ordinance. Talking about local legislation, here are some of the rules on local legislation. Ordinances cannot violate laws or cannot violate the Constitution. Ordinances are subject to review by the higher sanggunian. They are subject to veto by the mayor and the governor. The DBM and the DOJ can review and declare illegal ordinances on tax and appropriations. There are certain measures which should come in the form of ordinances, and there are certain measures which can come in the form of a resolution. And let me just jump to this because I think I've exceeded my time, but let me go through some of the issuances of the DILG. The DILG is the alter ego of the president. It is entrusted with assisting the president in the exercise of the power of supervision over local governments and to strengthen the capability of all local government units. The next set of slides are screenshots of a number of DILG circulars saying that local governments should discontinue narrow or limited window periods. There must be a system of priority for testing. Passes must be free of charge. LGU checkpoints must be overseen by the PNP, not by the barangay. Local governments cannot limit assistance to only those who are voters of that local government unit. Local government officials are not allowed to show their, to give credit to their own persons when giving relief to the citizens. Mass public transportation has been banned under the ECQ, including tricycles. DILG has imposed guidelines on curfew. Local chief executives are now prohibited from traveling outside their respective jurisdictions. There's now a ban on cockfighting. Gate passes must be free of charge. DILG has required that local governments must issue the corresponding ordinances, executive orders, or advisories on the mandatory wearing of face masks and social distancing. Local governments cannot impose number coding has now been lifted. Public transport is suspended, again, depending on the level of the quarantine. There should be an unhampered movement of cargoes. Barangay checkpoints must be removed, and again, only the police force can set up or supervise these checkpoints. For locally stranded individuals, local governments cannot deny the entry of these individuals into their respective territories. Local governments are directed to suspend the deadlines for the payment of taxes and fees. Again, this has now been extended to date up to June, which is next month. Funds of the Special Education Fund cannot be used for COVID, but funds by the Peace and Order Council can be used for COVID. Development projects, the development fund, which is 20%, can be used for COVID-related expenses, and sanctions will be imposed for violation of this rule. Supplemental budgets can be passed by local government units. Special risk allowance, the amount of which shall be dependent on the financial capability of the local government units. And this is an advisory from DILG. Takeover of operations, and this is again one of the emergency powers of the president. Local governments, according to this circular, has no power to take over. Only national government agencies has the power to take over under the Bayanihan Act. Local governments are enjoined to assist the DOT in identifying hotels for quarantine facilities. Now we go through some of the ordinances and executive orders issued and enacted by local governments. Here we see the Quezon City Mayor through a memorandum prohibits certain activities requiring certain passes. Cotabato City has issued 2 executive orders regarding quarantine. Ilocos Norte and Abra issued EOs regarding total lockdown. La Union and Mindoro have issued advisories and EOs pertaining to those who can enter their respective jurisdictions and the setting up of checkpoints. The Cebu governor, through an EO issued, and this was last March, prohibiting the entry of domestic passengers via air travel. Pasig has allowed the usage of certain passes and certain exceptions. Manila for District 1, and this is Tondo, last month has issued a 48-hour lockdown, total lockdown for Tondo. Curfew ordinances and EOs have been issued here by Makati and the province of Cebu. Closure of malls and enforcement of social distancing was adopted here by Mandaluyong and Caloocan. Requiring face masks, here I have 2 examples, one in Aurora and one for Ilocos Norte. Again, thank you for the League of Provinces for giving me copies of these ordinances. Mandaluyong and Caloocan for adopting anti-discrimination measures. Lifting or imposing liquor bans, whether consumption or sale. There was an EO by the mayor of Quezon City and 2 EOs from the province of Bataan and Oriental Mindoro. Anti-hoarding or anti-overpricing by Silang, Cavite, and Pasig. Tricycles by Makati and Davao City. Component units adopting the policies adopted by the higher supervising unit. Here we have Cordova adopting the policy of the Cebu province and Silang adopting the directives of the province of Cavite. For contracts, the Valenzuela City Council authorized the mayor, gave him general authority to enter into contracts and to affirm any contract which he may enter under the COVID situation. And last topic, before we proceed with our Q&A, will be about accountability and liability. Now more than ever, under the penal clause of the Bayanihan Act, local officials can be held liable for disobeying national government policies. Local governments as a juridical person can be held liable. Local officials can be held liable. Maximum penalty that a higher local government unit or the office of the president or a province can impose will be suspension. According to the Supreme Court, in a number of cases, said that only the courts can remove local officials. And again, under the local government code, local officials can be recalled through a special election during the second term of their 3-year term. Local governments can also be placed under preventive suspension. Under the local government code, after local government officials have filed their answers, they can be placed under preventive suspension. If a case is filed with the Office of the Ombudsman, then joinder of issues is not required. So again, before we proceed with the question and answer, let me just inform everyone that there are other materials which can be found in my website. That's albertociagra.com. I have this 1,500 page compilation of all Supreme Court decisions on local government. I have this updated version of my reviewer on local government law. And by the way, this PowerPoint presentation, which I just showed you, is now downloadable in my website in albertociagra.com.